should be recording. Normally I get a little message, but anyway, okay. All right, guys. Okay, so we're recording. I've now marked your assignments, and after this lecture, you'll each receive your assignment back with your mark. I go through them in quite a lot of detail. So if there's a spelling mistake, so you can see, you can expect like lots of handwritten comments and things like that. I really do feel it's useful for you. If you've got something wrong, I point it out. If you've got something right, there's a tick there, and often a little comment or something like that. So hopefully my feedback will be relatively comprehensive, and you'll see what I wanted and where you did good and where I felt that your efforts were a little bit lacking. But anyway, let's talk generally. I won't give everybody's mark out today, but I will give some feedback. So you'll each get your marks, and I'll leave it up to you if you want to share it with the rest of the group. But I won't give your marks out in the lecture today. Okay, let's talk about the assignment. Okay, so let's start with some general terms. Some of your assignments were poorly structured in the sense that they didn't have a beginning, a middle, and an end. They were just like a stream of consciousness, and then you sort of moved on to talk about South Africa, and then the US case, and then and it sort of all sort of flowed. What I really like to see in essays is structure, and I've got like a little sort of story that I tell my students and my kids, in fact. My daughter's at university as well. When you write an essay, when you write an assignment, it's got to be divided into three parts mainly. First of all, you got to tell them what you're going to tell them. Then you're going to tell them, and then finally you're going to tell them what you told them. Okay, so it's like an introduction, a middle, discussion, and a conclusion. And it's here's what we're going to talk about. Here's me talking about it. Here's what we spoke about. Okay. So that kind of structure is really cool. And when you do that, you can actually, then it begins to, you get like a logical, it begins to fall into place in your head as well, because you say, okay, first paragraph or two is an introduction. Then now I just need like 8 or 10 sentences, which will be my discussion. And then I'll have a conclusion, which is just a summary of the discussion. And my 8 or 10 sentences, I'll then just sort of expand into paragraphs. So what's my first sentence going to be? My first sentence will be, what is artificial intelligence? Okay. And my second sentence will be, who is an inventor? And my third sentence will be, how does the South African Act define an inventor? And so it goes. And then let's discuss artificial intelligence as an inventor in America is one paragraph. The European Union is another paragraph. Australia is another paragraph. The UK. Then some remarks, sort of just concluding all of that, saying, everybody seems to be of the view that AI is not an inventor because of the following reasons. And then a conclusion, just to say, AI is this. The South African Act defines an inventor as this. We've had these DABUS applications. They've all been refused consistently, with the exception of South Africa. South Africa is wrong for these reasons. Boom, boom, boom. As a result, it looks like AI should not, could not, is not recognized as an inventor. And then it's up to you to say whether this is a good thing or a bad thing. So, you just start off real simple, just sort of sentences, and then you just expand each sentence out. And then your essay just writes itself in a sense, and particularly if you've got that structure in your head. So some of you were more structured than others, and I think that's, probably that advice might be helpful in that regard in essay writing. I'm going to tell you what I'm going to tell you, I'm going to tell you, and then I'm going to tell you what I told you. If you build it around that framework, it works every time. Now, one thing that I did find a little bit disappointing was that some of your essays were very poorly drafted. And when I say that, I mean, it was clear that you guys, some of you guys hadn't read it, hadn't checked it before you submitted it to me. And I'm talking spell check, guys. I'm talking, there was one that just had dozens of spelling errors in it. Not cool. Not a postgrad, guys. We've got spell check on Word. Every word processing program has spell check. Use it. So shocking grammar. And now I know it's easy for me to say English is my first language. I can't speak any other language than English. And I get it. I really, really do. But I can't overestimate. I can't tell you enough how important it is that you've got to write good English. If you submit a legal argument, a letter, an opinion, and it's got spelling mistakes in, and it's got grammatical errors, like bad grammatical errors, like easily picked up grammatical errors, nobody gives any weight to that document, right? It's really difficult for any arguments which are contained in that document to find traction with the reader, because the reader looks at this and thinks, this guy can't even spell. So now I've got to like follow his intricate legal arguments. So no matter how good your legal arguments are, they will be significantly undermined by poor presentation, okay? Form over content every time. And you know, the English language is the medium by which we communicate. It is the medium by which, as lawyers, you will communicate your ideas, your arguments, your positions in negotiations, in cases, in opinions. This is how we communicate, not to mention it's how we communicate between each other. It's how we communicate with the other sex. So in all of these endeavors, there is no excuse for loneliness, for laziness. And so it's really, really important that you write well and that you use the spell check and you use the grammar checks that we have in Word. I mean, I'm a terrible speller. I'll be the first to admit it. I use spell check all the time. It's switched on as default on my. Very annoying that for some reason it switches itself off default from time to time. But no document goes out from my desk, without being spell checked. That's like rule number one. So I think that's really important to understand. I was a little bit disappointed that some of your essays included poor use of English, spelling mistakes, and grammar, and hadn't been checked by you guys. That was by the submitter. And you lost marks because of that. There's no doubt about it. You lost marks because of that. And I think that's right, because as postgraduate lawyers, we need to be able to communicate effectively and efficiently and in a manner that people sort of take notice and your ideas and your arguments find traction. So I just wanted to mention that as a kind of general point first. Okay, so let's go back now to the assignment, and these are the kind of ideas that I was looking for you to explore in the assignment. And so I will put this as a memo. I won't give you a written answer, a written model answer, but I'll give you a memo about what we're talking about now, and I'll issue that. It'll go up on Blackboard so you can see. But the kind of things that I expected you to cover in your assignment was as follows. Okay, first of all, it was all about artificial intelligence, right? Because it's so topical and it's Dean and Dyer at page 252 states that an inventor can only be a natural person. Do you agree with this statement? Discuss. In your answer, you should review the Patents Act with particular attention to the wording used to refer to the inventor throughout. Okay. If non-natural inventors were to be permitted, what effect would this have on section 2510 of the Act, which deals with inventorship? Also include in your discussion a review of recent announcements in this regard from the European Patent Office and the United States and the USPTO. Okay, so I don't actually mention artificial intelligence in there, but obviously you all picked up that was exactly what I was after, right? I think I might have given you a clue in one of the lectures, subsequent lectures, I'm not too sure. So So initially, so this is a course in South Africa about the South African Patents Act. So I really wanted quite a good analysis of the Act. And basically, Dean and Dyer 252 states an inventor can only be a natural person. Really? But the Act doesn't say that. You know, the Act implies that. And most of you were on the money there, because what we're talking about is there's no definition of inventor, but later on in the Act, we refer to him using pronouns, him or her, which implies a natural person, right? So I really wanted you, I wanted you to pick up on that point, which most of you did. You just, I think what you quoted a section every now and then. I can't remember which section it is. It's yeah. Some of you just said the Act refers to the inventor as him, and without a citation. Oh, that's another thing. If whatever you say, if you ever make a factual affirmation citation, tell me where you got it from. You can't just pluck these things out of the air. And some of your citations were wrong as well. Some of your citations were super sloppy, where you say refer here and then you refer it back, and that's not right. Yeah, I check your citations, so don't try to pull the wool over my eyes with citations. They've got to be rock solid, and not all of yours were. So yeah, anyway, so there are a number of occasions in the Act where they talk about him or her, and I really wanted to kind of list all of them. Some of you mentioned only one, and I think it's that bit about any person. Let me just get the Act up here quickly. Can apply for. Actually, wait. Let me just get the Act up here. Where is it? One sec. Here we go. Where are we? It's the sorry, it's who may apply for a patent. Yeah, here we go. 27.1. An application for a patent in respect of an invention may be made by the inventor or by any other person acquiring from him the right to apply, or by both such inventor and such other person. That, and most of you got that one. So you referred to the Act referring to an inventor as him, but later on, and I can't believe none of you chatted, spoke about this, because it's really quite an important part of the society. Section 45. Section 45 talks about him or her, and it's also relevant. So that's another example of the use of anthropo pronouns to refer to the inventor, which carries the strong implication that inventors are only natural persons, right? But Section 45 does that, in addition to this 27.1, and there are various other references to inventors as him or her. But Section 45 also talks about the whole of your endeavor, and etc., etc. And the machine doesn't care about enjoying the fruit of its endeavor or whatever. So that was an argument that you kind of, some of you just like skated, or you came close to it, but none of you spoke about Section 45 per se, which is like a double word score, because it covers both of those aspects. One of you mentioned, and I thought this was very cool, you quoted from the Interpretation of Statutes Act, saying that where you talk, if it refers to the masculine, by definition it includes the feminine. And I like that. That got a definite nod from me. But only one of you spoke about the Interpretation of Statutes Act, and I think it's important. So I felt that we were a little bit light on our analysis of the South African Patents Act and how we refer to inventors and the pronouns used and that kind of thing. So, marks were lost for that. I mean, this is a South African course. I would have expected you to really give that. And, in the question I say, in your answer, review the Patents Act with particular attention to the wording used to refer to the inventor throughout. So I wanted more than just a casual reference to 27.1 calling the inventor him. There are multiple uses of pronouns referring to the inventor, and I wanted you to be sort of quite more thorough in your analysis on that basis. Okay. But, okay. So in your assignment, we should have covered what is AI, and most of you got that. There's a million definitions out there, Wikipedia. A lot of you found really, well, you all found really, really good. I mean, well, there's a lot to find out there, you know, discussion on this and everything. So you're able to pick up definition of AI quite quickly, but that should have gone in. Then most of you were talking about it, what an inventor is in terms of the South African Act and how it's not defined, etc., etc. But as I said, I would have liked a more comprehensive review of the Act to pick up every use of the words him or her. Okay, and then you know, to talk about the South African position, this is kind of what I was looking for, and most of you got this, that South Africa is a non-examining country. Well, we don't have substantive examination. Okay, nobody spoke about section 34, which says, I'll just get it up here quickly, which talks about examination, right? So, and then you've got to read it in relation to the regs, which says that it's only formal. So section 34, I mean, it's right there. The registrar shall examine in the prescribed manner every application for a patent and every complete specification accompanying such application or lodged at the Patent Office in pursuance of such application, and if it complies with the requirements of this Act, he shall accept it. Okay, so technically we're an examining country, but it says examine in the prescribed manner. So, well, what does that say? Well, now we go to the prescription, which is Regulation 40 to 43. Okay, and here it says any application accompanied by provisional specification shall be examined to show the contents lodged are legible and capable of reproduction. The registrar shall examine the application accompanied by complete specification in order to ensure that it complies with the prescribed formalities. Okay, so our examination is not substantive. Our examination is only formal. Now, most of you said that, but very few of you said section 34 read with regulation 41. Okay, so we need to be precise about that. Okay, so we've got this examination, and for some reason, SIPSI, oh, that's another thing. Some of you call it the South African Patent Office, some of you call it the Patent Office, some of you call it the SIPSI. It's SIPSI, CIPC. It's, you know, let's be consistent in our referrals. And yeah, as you know, one of you quoted a paper saying that the decision to allow the patent application, even with formal examination, is bad in law and won't stand up to judicial review. Okay, and there were a number of reasons why. Because of the personification used in the Act with the pronoun, similarity between our law and particularly UK and European law, which is highly persuasive in South Africa. So one or two of you mentioned that. EPC is highly persuasive here, but there's a really good paper that that none of you picked up on, that I wanted to just read to you, and it covers. So it's on our website, the Sport official website. Okay, so, and it says here, it quotes one of our partners, and he says this. In South Africa, our patent laws contain no definition of an inventor and no substantive examination is required. As long as the formal requirements are met, the patent can be granted, which is exactly what I've been talking about, right? 34 read with 41. But then he goes on. However, in the case of Davos, did Taylor, the co-applicant, obtain the right to apply for the patent from a machine? Unresolved difficulties of this nature could result in the patent being contested in the future. Okay. It is a requirement of South African patent law that if the applicant for a patent is not the inventor, the applicant must provide proof of their right to apply in lieu of the inventor. As Davos has been cited as an inventor, how could the machine decide to assign its rights to its creator? And furthermore, how is this possibly effected in reality? Okay. we're saying is, it's that section in the Act which says you've got to, if you're not the inventor, you've got to acquire the rights from the inventor. And how is a machine supposed to transfer those rights to Dr. Taylor in this case? Okay. And so that's where it should fail on a formal level in South Africa before we even get to you know, what's an inventor and what's an invention, and et cetera, et cetera. It fails on that formal aspect that even if it wasn't, if he was deemed to be an inventor, this artificial intelligence, he couldn't transfer it to somebody else. How's the machine supposed to do that? So so that we feel is one of the main reasons why the South African decision is wrong. I mean, there are other reasons which you all explored, but nobody picked up on that, and it's that transfer, acquiring the right to apply from the machine. So, so I would have liked to have seen that. Okay, most of you picked up and gave good discussions on the DABUS multiple applications in different countries. So we call those the corresponding applications to the South African application, the US, the UK. European Patent Office, and then some of you didn't discuss Australia, which is strange because Australia was the one outlier, and those of you who did discuss Australia, only one of you figured out that, in fact, so there was in Australia there were three decisions. The first one, the Patent Office said, "I corner this; it's not an inventor." Taylor took it to a single judge in the federal court. He said, yes, it is an inventor applying, you know, a broad interpretation to the statute and, you know, the balance of convenience and all of that, all of those arguments, which all of you went through quite well. But only one of you picked up that that decision of a single judge has since been overturned by a full bench of the federal court in Australia, bringing Australia back into line with UK, the US, Europe. So right now, South Africa is the only country that's outstanding in accepting an AI as an inventor, and everybody says that that's wrong. So, so I would have liked to have seen that, but your discussions were good. What have you discussed Germany, which I thought was cool. That was nice, and you were very comprehensive. And I think you also the same person chatted about China, and I liked that. That was good as well. So, you know, that's exactly what I wanted. I wanted sort of comparative outlook on how everybody else was doing it and the different reasons, et cetera, et cetera. So the reasons in the UK and the reasons in Europe are particularly relevant in South Africa because, you know, that legislation is so similar in wording to ours, and as a result, any judicial findings or interpretations of that wording, although not binding, are highly persuasive in South Africa. So and again, several of you picked up on that point. Okay, similarity between UK and particularly the UK and ZA legislation, but also to the extent the EPC is persuasive in South Africa. So those are the kind of arguments that I was looking for. When turning now to 2510, which is the inventive step, most of you, you know, engaged with that, and I like that. And that is talking about a person skilled in the art. So now, you know, what's a person, and how would AI generated inventions, how would they affect what is prior art and how you interpret prior art and all of that. And guys, I know that's a tricky discussion. That's like a slippery eel of a concept to try and very difficult. And I was actually quite pleased with how you all handled that. You got stuck in, and I like that you all had to go. And you know, when you talk about something like that, I'm not going to say to you, oh no, your interpretation is wrong. I just like the fact that you've mentally engaged with that slippery eel of a concept and try to get hold of it, and I like that. So you guys did good on your reference to 2510. And then finally, just one or two more things. A lot of you said a person is a natural person. That's not true, because a person can be a legal person, right? A legal entity can be a legal person. So we must distinguish between natural and legal persons, and not everybody appreciated that difference in your assignments. So that was just an important point. Some of you spoke at length about how you know, if the owner of the AI, the creator of the AI, should by definition own its outputs. And I would have liked to have seen some crossover there because I'm sure you would have considered that in your copyright course last year. But, you know, so like songs and works of art and poems and even books have been written by computers and code programs now for quite some time. And the Copyright Act is real simple. It just says whoever created the code, whoever owns the code, owns its output. And so, you know, there was the implied argument that carries over into AI, but nobody made the connection with copyright. I think one of you might have mentioned copyright, but you know, but also we didn't talk about there's a difference between AI and a program. All right, so I don't know if any of you have ever read that book called it's by a Nigerian author, and I can't, his name escapes me for the moment, but it's called Things Fall Apart, and it's the title comes from a poem by Yeats, and he's talking about how a country comes apart at its seams, and he says the line from the poem goes, turning and turning on the widening gyre, the falcon cannot hear the falconer. And what he's talking about is, you know, if you've got a falcon and you let him go and he circles up and up and up, there will come a point where he flies so far away from you that he can't hear your commands anymore. And that turning and turning on the widening gyre is like a cone of flight. The falcon cannot hear the falconer. And that's exactly what artificial intelligence is like, in the sense that, you know, we create these sort of electronic entities, and they have some degree of sentience, and they grow and they acquire code of their own, and they discard code that they don't need. So when you create artificial intelligence, it's very quickly, it's difficult to track who created the entity, because you release it on Monday. On Tuesday, it discards half of its code and takes on board code that it found somewhere else that's nice. On Wednesday, it does the same and iterates and iterates. By Friday, it'll have very little of the code that the original creator created, you know. So, and it might have gone through several iterations. So it's not the same thing. It's a sentient self-iterating legal, well, sort of electronic entity. So it's code, and then the code does something. This thing, you know, it's like a cloud. It lives and breathes and moves. And so ownership is virtually impossible to track. And nobody really made that point about how self-iterative AI is, and AI quickly doesn't hear the falconer anymore. It bears little or no resemblance to its creator, and it's way out of the creator's control. So, you know, that I think is a relatively important aspect. And that's why AI is subject to so much discussion at the moment, which is leading into my last point, which is the ramifications of recognizing AI. You know, Elon Musk, who you all have heard of, that AI is the greatest threat to humanity. He thinks it's an existential threat, and I'm with Ellen. I think he's right. I think we could release AI that takes on sentience and considers us to be a stain, you know, and sort of figures that it's in everybody's best interests if we don't exist anymore. And I think that's highly likely. You know, maybe I've watched too many Terminator movies with Arnold Schwarzenegger, but from a philosophical level, that's entirely possible, the way things are going. Mark Zuckerberg of Facebook is of the other opinion, and him in his metaverse seems to think that AI is the best thing that's ever happened, and it's our ticket to the next level. But either way, if you unleash AI out there and you start granting it rights, ownership rights, I think you're opening Pandora's box, you know. Would you like, so now we're saying, okay, AI exists as a legal entity. as a species of legal person, like a company or a natural person. Now it can own property. So now all of a sudden your landlord is AI. You have to pay it, and it decides when you go, and it decides who can stay in your flat, and etc. etc. AI owns shares. AI start manipulating share prices because it needs to maximize its value. So if it owns, it's going to start bashing Kumba or Implats or something like that, because that would increase, Anglo's share pricing. So, all of these things. And one of you made the point, which is really good, is that if you allow AI to be listed as an inventor, then you're just going to open the floodgates. It's just going to be a sausage machine, and we're going to drown in innovation as these things just start spitting out patents as they solve problems. And so the standard for prior art will just skyrocket. We will be out-muscled. Humans will be out-muscled from making inventions because the prior art will be so huge that the standard of inventive step will be almost unattainable. And so that's why your discussions of 2510 were really important as to what constitutes prior art, ownership. And then on what basis is AI going to allow transfer or license discussed today? And then finally, we always come back to section 45, which is, the heart, which is talking about, let's just get 45 up because it's just such a good one. The effect of a patent shall be to grant to the patentee in the Republic, subject to the provisions of this Act for the duration of the patent, the right to exclude other persons from making, using, exercising, disposing, or offering to dispose of, or importing the invention, so that he or she shall have and enjoy the whole profit and advantage accruing by reason of the invention. Does a machine want the whole profit and advantage accruing by reason of the invention? What's it going to do? So that's not a motivator for a machine. And given that, the Patent Act is based on motivation, it all hinges off incentivization and the quid pro quo. By allowing a machine into this paradigm, you're undermining the paradigm, because the machine doesn't give a monkeys about the whole profit and advantage. It's just doing what it's designed to do. So, yeah. So I think AI as an inventor offends Section 45(1) on a sort of philosophical level, and that wasn't really touched on because nobody spoke about 45 in your assignment. So yeah, there we go. Those were the discussions I was looking at. Most of you got most of them. Nobody got all of them, but that's not to be expected. And as I say, just to confirm, some of you had good structure, some of you had read and checked them, some of you had bad structure, some of you hadn't checked them, and your arguments ranged from good to very good. There was nobody who failed, because you were all kind of hitting what I was looking for, relatively speaking, here and there. And yeah, so that's the feedback. And as I said, later today, I'll scan all of these in, and then you can see my detailed comments on each of them. And if you have any questions, then feel free to contact me directly, because I appreciate you might not want to speak about these in open form. So that's my analysis of your assignments. Thank you for the hard work. Generally I was pleased. And yeah, so now we move on. Before we start today's lecture, which is unfortunately quite a long one, do I have any questions on the assignments going forward? Okay, cool. So what we're going to talk about today, as a side for one moment, is it's referred to as journal, but what it is in practice is chapter 9 of Dean and Dyer, commercial considerations for transactions involving intellectual property. Okay, so this has relevance to both, to all sort of species of intellectual property, patents, designs, trademarks, copyright, and know-how to some extent as well. And what we'll be talking about is assignment, licensing, hypothecation and attachment, which is quite interesting, exchange control, and then, I don't know if any of you have ever dealt with this, but it is such a thorn in my side, a stone in my shoe, a pain in my neck. Intellectual property from publicly financed research and development. Okay, you need to know about that, and we'll discuss that easily today. So, okay, so it's the whole of chapter 9, but it's only insofar as it relates to patents and designs. I'm not too sure last year in your trademark and copyright courses if you did much assignment and that kind of work, but I can tell you that in my practice, assignment, licensing, hypothecation, that kind of thing, exchange control, huge, and that flippin' IPR Act at the end, that's a good 60 to 70% of my practice. I deal with this stuff all day, every day, certainly. So it's really important because this is. So now we're presupposing that you've got your patent. Okay, you know how the patent system works, and inventive step, and novelty, and whatever. You've paid your fees. So now you've got this thing, right? And it is a thing, and it's a piece of property. And what are you going to do with it? Okay, so when you've got a patent, you've paid your patent attorney all of this money to get you this monopoly, this right to exclude others, so that you can enjoy the whole profit and advantage. So how are you going to go about enjoying said profit and advantage? And there are a number of ways that you can do that. So the first is, and most common, which it goes without saying, is you can exploit the patent yourself. You can start making these widgets or bras or whatever you've got, your patent on yourself, and you'll have cleared a little bit of space on the platform where you can operate and you can exclude others from practicing your invention. That's great. Off you go, and you do your own thing. So you use it yourself. But by far more often than not, you don't have the resources, you don't have a factory, you don't have a distribution network. You need help. You need partners to get this off the ground, to really be able to satisfy the needs of the market. So you look to onboard others with your idea, or you look to let others take your idea and run with it. So the first thing that you can do is you can sell your patent, lock, stock, and barrel. Okay, so somebody comes along and says, man, I really like that technology. That's really cool. Here's $1 million for it. And you say, where do I sign? Of course you can have it for $1 million. So that's straight up assignment. And that's just like selling your house or your car. So one day you're living in your house, there's a knock at the door, your neighbor says, I'd like to buy your house. You say, I want $1 million. Neighbor says, cool. You sign the agreement and you send it to the attorney, and the deeds office registers the transfer and title from you to your neighbor. And then from that day, you don't own that property anymore. You have no more rights to stay there. If you want to stay there, you have to ask the neighbor who you just sold the place to, please, can I stay? You should ideally do that before you sell, but it's exactly the same with a patent, right? You have the right to exclude others from making and selling widgets. Dude comes along, offers you $1 million, you sign it, all of a sardine, you have no more rights to make that widget because you sold them in toto to the other guy. Okay, so that's an assignment of a patent. And there's just a couple of little formal things. Has to be in writing, okay, according to Section 61A of the Patents Act. And the other thing, which is a little bit tricky, is that you should record it on the register at SIPSI, at the Patent Office, because if you don't, that assignment is not valid inter partes. It's only valid in parties. It's not valid against third parties. So you might, so if you've bought a patent, you definitely want to record that assignment, because otherwise you're not shown on the register to be the patentee, which means you can't sublicense it, you can't on-sell it, and most importantly, you can't start an action for infringement of it, right? Because only the recorded patentee can be an infringement. So it's very much in your interest that you record it. And you've got to record it within 6 months of the date of transaction. Otherwise, you pay a fee. I mean, obviously, you can ask for condonation for late recordal, and they're very forgiving in that regard. But generally, the Act says you've got to record within 6 months of the transaction. The other thing is that, normally when you sell a patent or something like this, it's quite a complicated agreement. Assignment agreements are not generally one pages. They're quite thick, and it's got all the pricing details and how much is paid and et cetera, et cetera. And you don't want that public knowledge, right? So you don't want that agreement on file at the patent office where everybody can see it. So what you tend to do is you execute what's called a confirmatory deed of assignment, which just says that on this day, I sold the patent to this guy, and including the right to claim damages, claim priority, whatever, and then both of you sign it, and that little one page, that confirmatory deed of assignment, that's the one that's placed on file at the patent office, and the actual full-blown deed of sale remains confidential between the parties. So that's how it works in practice. So that's assignment, easy peasy, okay? Dean and Dyer talks about trademarks and partial assignments, etc., etc. Bear in mind, of course, that a joint proprietor of a patent is not able to assign his undivided share in the same without the consent of other joint patentees, co-proprietors, unless there's an agreement between the parties to the contrary. So you need to consider, which, reason number 50,000 why I hate joint ownership, because you're so constrained, you can't, there's almost nothing you can do. And then they talk about copyright as well, but we're not really worried about that. The big one, by far the most common one, is licensing. Okay, so licensing is basically renting out your patent or your design to a third party, just like you would rent out your house. So you would typically move out of your house, although you don't have to. You would move out of your house and you'd grant use of your house to another person for monthly rent. Okay, and it's exactly the same in licensing out patents. You sort of give up occupation of that little monopoly area and you let somebody else use it, and in return they pay you rent, which is a royalty. Okay, that is a massive oversimplification of licensing, because when you do a license agreement, you go large. Okay, I'm going to uppost onto Blackboard the 27 considerations that have to be taken on board in licensing. Okay, and there are so many ways to slice and dice a license agreement. Okay, you can say, so generally, in its most simple form, you say, I've got this patent, South African patent number, whatever, it's granted, it's in force, and I give company A the full right to exclude other persons from making, using, exercising, disposing of, offering to dispose of, or importing the invention. Section 45 again coming in. Okay, and they can do it in South Africa. They can include everybody in South Africa across the whole field of the invention for the life of the patent, and then they will pay me 10% of every widget they sell. Okay, now you say that's cool. Now I've got a few questions about that arrangement. First of all, can you, the patentee, still use that patent, or have you given away all your rights? Because there are three ways that you can license a patent. It can be exclusive, an exclusive license, which means that you, the patentee, don't get to use that. You've given up your rights. You move out of the house, and the licensee has got the exclusive right to use it to the exclusion of the patentee. You've got a non-exclusive license, which just says that you're one of many licensees. I still retain, I let you use it, I let you use it, I let you use it, and you're all paying me royalties, but you're all competing with each other. So, the prices are going to be low, and, the market will be segmented, so there's no monopolies. Everybody's just fighting it out there. And then there's the third one, which is a sole license, which is where the patentee retains the right, and he only gives one license, and that's to the sole licensee. So it's the licensee and the patent proprietor. So the two of you can exploit it. So that's the first thing. So the question is it exclusive? Is it non-exclusive? Or is it sole? Okay. So this is a quick way, a shortcut to tell if you're dealing with an idiot on the other side in a license agreement. Because if he sends you a document and it describes the license as sole and exclusive, you know you're dealing with an idiot, because that's wrong. You can't say sole and exclusive. Sole means one thing, exclusive means another thing. They're not the same. So that's one of the first things you've got to figure out. Is it sole or is it exclusive? Then you've got to say, okay, what's the subject of the invention? Because, like, I might only give a factory the right to make it, So I license a factory to make it, but I license only game stores to dispose of it, to sell it. So I'm dividing up Section 45. You've got the rights to make, you've got the rights to dispose of, okay? Then I can divide it up and I can say, you've got the rights to make in Gauteng, but Company C has got the rights to make in the Eastern Cape, and Company D has got the rights to make in the Western Cape. So you're dividing up the country geographically speaking. I might have my patent in more than one country. So I could say Company A has got South Africa, or Company A has got Gauteng in South Africa, Company B has got the Eastern Cape, Company C has got Zimbabwe, Company D has got the United Kingdom. Wherever I've got my patent rights, I can grant them differently, right? I can say, so I can divide it up in terms of the subject of the license, or the acts, what you can do. If my invention relates to, can be used across different technologies. So, I can use it to make bicycles here, but I can also use the same technology in cars. I can license it for cars here and for bicycles here. So, there's a lot of ways. I could say that you've only got it for 10 years and then it reverts to me. And so you can really sort of like slice and dice geography, time, subject matter, excluded acts. You can really go crazy. But then there are all sort of different questions like, how much royalty are you going to pay me? Is it going to be, what percentage is it going to be? And is that percentage is usually calculated on the manufacturing cost, or what's called the ex-factory cost of the product. So say I make, a mouse for a computer. I'm licensed to make this mouse, and I make them and I sell them on to Incredible Connection for 100 Rand each. Okay, Incredible Connection then sell them in their stores for 250 Rand each, but I, the manufacturer, only got 100. The royalty is not based on the 250 selling price on the shelf at Incredible Deception. It's based on the $100 that I charge for it. And what percentage of that? Is it 10%, 5%, etc., etc.? Sometimes you can just say, I don't care how many you make, give me 250,000 every 3 months. And if you make 1 million of these things, good for you. If you make 0 of them, I don't care. I get my 250,000. And that's sort of what we call minimum performance. And that's what you need to do if you are exclusively licensing somebody, because if I exclusively license you to make these widgets, and even I'm not allowed to do it in terms of the exclusive license, that's a problem, because you could just sit on your bum and not do anything. And if I didn't have that minimum performance clause in there guaranteeing me 250,000 Rand every 3 months, I would get nothing. And there's nothing I could do. I couldn't even start making these mouses myself, because I was excluded in terms of the license. So it's really important that if you're completely giving the rights away, licensing the rights on an exclusive basis, it's got to be back to back with exclusive minimum performance rights. Okay. The other thing you've got to figure out is, I license you the right to make these mouses, and then somebody out there starts infringing the patent. I'm one who can sue them, but I don't feel like doing that. So, I just let these other guys get away with murder. I'm not obliged to sue them. Most license agreements require the patent proprietor to go and sue any infringers of the intellectual property. Because otherwise the licensee would be like, well, what am I paying for? You're just letting him get away with it, and I've got to pay a royalty. Forget it. I'm walking away. I'm not paying my royalty. So there's got to be an obligation on the licensor to go and squash any acts of infringement. And bearing in mind, of course, that as we discussed last week with infringement, only the proprietor can do it. And also, it's a good idea to record the license, because if I'm a proprietor, then I have to give my licensee notice that I'm instituting infringement proceedings, and then the licensees can co-join as co-plaintiffs, because they are the ones who are suffering damage. So they need to be part of the action. So that's why it's really important to record licenses. So that's when somebody else a third party is infringing our IP. What happens if I license you, you start merrily making and selling these mouses, and the next minute, boom, you get sued by Microsoft to say, hey man, You making that mouse, that infringes our patent, okay? I'm going to turn around to the licensor and say, what the hell? I've got these rights, and now I'm being sued. So the licensor usually has to indemnify the licensee and give them a warranty that in practicing the act, the license acts, they're in fact not going to infringe any third-party IP. And if they do, they're indemnified against any costs that might happen, okay? So that's another thing license agreements have to figure out. Then another thing that license agreements have to deal with is what happens if I license you how to make mouses and you make an improvement to the patent. You say, oh, yours is a great idea, but how about we use this circuit board instead of the one that you tell me to use. The mouse is lighter and faster and more clever. And that's an improvement. So then now we've got a fight on our hands because you say, the licensee says, well, I made that improvement. It's mine. I'm the inventor. I need to own that invention. And you as the licensor say, yeah, but you would never have made that invention but for me telling you how the mouse works so that you could figure it out and you are in possession of the invention and now you've iterated it and improved it. So sure, you've made that improvement, but if it wasn't for me, you would never have made that improvement. So you need to figure out right at the beginning, before you sign a license agreement, who's going to own improvements, right? And it's relatively easy to sort all of that stuff out, but it's definitely something you've got to address while you're all still friends, yeah? Because it's when the money's on the table, that's when the fights break out. It's a good idea to cover all of these aspects before things really get hot. So that's important. There are, several other things about in license agreements that are important. Like, I don't know if we've ever spoke about marking, but if you look at in the Patents Act, where is it? So you marking patent products as it says here, section 66. A patentee shall not be entitled to recover damages in respect of infringement of a patent from a defendant who proves that at the date of the infringement he was not aware and had no reasonable means of making himself aware of the existence of the patent, and the marking of an article with the word patent or patented or any word expressing or implying that a patent has been obtained for the article, stamped, engraved, impressed, or otherwise applied to the article, shall not be deemed to constitute notice of the existence of the patent unless such words are accompanied by the number of the patent. Okay. So what does that mean? It means that when you buy your mouse, it's got to say South African patent number, wada, wada, wada on it. Otherwise, you can't get damages from the date until you send them by registered mail a copy of the patent, any infringer, to say this mouse is the subject of a South African patent. If the product is marked in terms of 66, then you can get damages from the day they start selling them. If it's not marked, you can only get damages from the day you tell them that it's the subject of a South African patent, and you would tell them by way of a registered letter. So license agreements deal with marking of products. Do they want the product marked or not? They deal with whether you record the license at the patent offices around the world. I think that's quite an important thing, as I've spoken about. If you're not recorded as a licensee, you can't join any processes for infringement. There's other things like what's the governing law of the agreement? Because if I'm in South Africa and I've got a UK patent and I'm licensing somebody in the UK to use my UK patent, which law governs that agreement? Is it the law of England and Wales? And I just need to tell you now, another shortcut giveaway that you're dealing with an idiot is when they talk about UK law or English law. There's no such thing, okay? In the UK, you've got the law of Scotland, and then you've got the law of England and Wales. You don't have English law. You don't have UK law. You don't have British law. You have Scottish law, or you have the law of England and Wales. So if somebody's using that precise language, you know, dealing with somebody who knows what they're talking about. If they come back and say English law, you know you're dealing with an idiot. And it's always good to know that. So so that's just, governing law. Governing law can often be a huge fight. So because your English guy is going to say, oh, of course it's English law. I'm making this stuff in England. I'm selling this stuff in England. The patent is registered in England. It's the law of England and Wales that applies. End of story. And you're like, I'm not going to go to the UK to fight because you decided not to pay me. I'm completely disadvantaged by the use of English law. It should be South African law because I'm the guy who invented it. I own the patent. I'm in South Africa. It's South African law. And, how do you argue against those two things? So what we normally do is choose a mutually disagreeable legal system which applies to the agreement. So that would be, so you'd insert a clause that says something along the lines of, this agreement is governed by the laws of Singapore, or this law is governed by, this agreement is governed by the laws of Australia, or whatever, So it's neither of your laws. And both of you have to go to Singapore to fight this thing out. And that works really well because, like, Singapore law is good. It's kind of like, it's based on UK law. They've got a robust legal system there. You could get a good judgment, but both of you have to go and fight there. Both of you are equally disadvantaged to go to Singapore. So that's a strong incentive not to litigate on the agreement and to reach some kind of agreement. And so, that tends to be the way we solve that conundrum on governing law, by choosing an equally disagreeable jurisdiction for the agreement. So licensing agreements include all of those kinds of things. So you can see when I do a licensing agreement, it's really very involved because, you've got to answer all of these questions. Do I have to sue? What rights do you have to improvements? In what geographic area is it? How do you pay me? How much do you pay me? When do you pay me? Also things like, there's a million things. Do I have the rights as the licensor to inspect your books? Because, you told me you sold 100, but I need to see your books. Maybe you sold 1,000 and you're just holding 900 back. I don't know. I've got a whole lot of skills on how to make these mouses. How do I transfer them to your workforce? And if you've got a problem, do I have to help you? If you can't get your production facilities to work, as the licensor, am I obliged to send somebody to give you some sort of technical know-how on this? So, from that point of view, those things are all covered in license agreements. The license agreements are thick, they're expensive to draft, and they're very comprehensive in what they cover. And this will be set out in a checklist of questions, which I will send to you. And this is typically what's covered in a license agreement. Dean and Dyer covers that to some extent. So you can see I've chatted about the field, the nature of the license, non-exclusive, sold, exclusive, the duration of the license, the territory of the license fees or royalties, sub-licensing. Oh, that's a good one. As a licensee, so I've got the rights from you. Am I entitled to sub-license anybody else? And if I am, how do the royalties flow from them to me to you? And so sub-licensing is an important and tricky aspect of it. A sub-license involves the licensee who has acquired the right to perform certain acts from the licensor, in turn granting some or all of these rights to a third party, which is known as the sub-licensee. And a license agreement should always deal with whether or not the licensee is able to grant such sub-licenses and the conditions under which sub-licenses are granted. Okay. As a licensor, that's tricky because you need to exercise some control over the sub-licensing of the rights. So, for example, you need to be able to say you can sub-license to him but not to him, because you don't want your licensee sub-licensing out the back door to a competitor of yours who suddenly then has access to all of your information and how you do things. So I think that's important that sub-licensing is tricky. Most licensors just say, no, you can't sub-license, end of story. But sometimes you can maximize your revenue streams by doing that. So sub-licensing is important. Okay. Then talks about the other important license terms which we've discussed, and of course the importance of recording the license. because as a licensee, you're not entitled to join proceedings for infringement unless you're recorded as a licensee. Now, one thing I want to talk about is that Section 90 of the South African Patents Act specifically prohibits certain provisions in patent license agreements. And I'll just go through them now. There's 5 of them. So Section 90 directs that a licensor cannot prohibit a licensee from purchasing or using any article supplied or owned by a third party. So for example, a license agreement stipulates that the licensor would be the exclusive supplier of an unpatented article, which is freely available on the market. But the license says you have to buy it from me, the licensor. That provision would be null and void in terms of Section 90. A licensor cannot prohibit a licensee from using any article not protected by the patent. So a licensee cannot, for example, be contractually restrained from using an article that could be a substitute for the patented article or method that forms the subject of the license. Okay, that's a little bit tricky, but like if it says, if it's not part of the patent that you need to use a particular type of spring, I can't make you use that type of spring. If you could buy another type of spring, say for example a leaf spring as opposed to a coil spring, and the patent is silent about that, I can't make you use the coil spring if leaf springs are available on the market. A licensor cannot require a licensee to acquire any article from the licensor other than that which forms the subject of the patent owned by the licensor. Okay, that's clear on the face of it. Most important and anti-competitive. A licensor cannot require a licensee to impose a specified minimum resale price in respect of any patented article. So I can't tell you how much you have to charge for the patented article. That's quite important. And a licensor cannot prohibit or restrict the making, using, exercising, disposing of the invention in any country in which the invention is not patented, obviously. So if I don't have a patent in Zimbabwe, I can't stop you as a licensee, or indeed I can't stop anybody from making or using that invention in Zimbabwe. I can only license rights in territories where I have filed for the patent. Okay. So that's a voluntary license. That's where 2 consenting adults come together and say, you know, I like what you've got. How much to let me use your invention? And, you know, we reach an agreement on that basis. But sometimes where a patentee is not willing or able to work a patent himself, and he can't find any prospective licensees, he can endorse the patent on the register with the words licenses of right. And this means that any person is entitled, as of right, to a license under that patent, and, you know, under reasonable terms. So it means that the licensor can't say no to somebody who knocks on the door and says, I'd like a license to that patent because you've endorsed it, licenses of right. Now, why would a patentee do that? And it's because if you choose to endorse your patent with licenses of right, your renewal fees, you get a 50% discount. So the renewal fee payable in respect of a patent endorsed with the words licenses of right is 1/2 of the renewal fee that would apply if the patent was not so endorsed. So, you know, that's interesting. Also, interestingly, in the case of infringement, the licensee of a license granted through licenses of right may call upon the patentee to institute proceedings, and if the patentee fails to do so within 2 months, the licensee himself might institute proceedings for the infringement. So that's an exception to the rule that only the patentee can institute action for infringement of the patent. So that's quite interesting. All right, what I want to chat about now is compulsory licenses, because compulsory licenses are quite important, and they were very topical recently with the discussion of the COVID vaccines, right? So a lot of people felt that the proprietors of the patents that related to COVID vaccines should have allowed everybody to practice the patents. They should have just, you know, they should have made them publicly available. But the argument of the patent proprietors was that there are existing provisions in the Act which allow for third parties to gain access to patents in the form of a compulsory license under certain defined conditions. And this is really important. So the Patents Act provides, well, the first is dependent patents. Don't worry about that. But in the event of abuse of patent rights, given that there are monopoly rights, which is the right to exclude others from making them, it is possible that a proprietor could abuse these rights by refusing to work the invention adequately in South Africa to the detriment of the public, right? So both the Patents Act and the Designs Act contain provisions aimed at preventing the abuse of the rights conferred by a patent or a design. So in a very trite example, imagine that you had invented a light bulb that never burnt out, okay? So you just bought one light bulb and that would be it for the rest of your life. You never have to buy any more. And this patent was bought by Philips or Osram or whatever, and just put in the safe and never used, because they make their business selling light bulbs. So people buy them to replace light bulbs that have burnt out. So in that case, they don't want people knowing how to make a light bulb that never burns out, because they'd only ever sell one and they'd never sell another one. So that's no good, because their business is repeat sales when these things burn out. So compulsory licenses are aimed at where the proprietor would be abusing the rights in the patent. So he's sitting there stopping everybody from making these light bulbs that don't work out, but he's not making and selling them himself. So he's abusing these rights to the detriment of the public. And there are a number of ways in which rights in a patent or a design can be deemed abused, and they are the following 5. Okay, and this is set out in section I think it's 56 of the Patents Act here. If the invention is not being worked in South Africa on a commercial scale or to an adequate extent, and without any satisfactory reason for such non-working, okay? So if the demand, so it's not, you know, you can only get them, you can't get enough of them, the market is not being satisfied, then that's deemed to be abusing a patent, okay? If the availability of the articles embodying the invention is being prevented or hindered by the importation of such articles, not too sure about that. 101, that's I think that's mainly designs, yeah. If the demand for the invention in South Africa is not being met to an adequate extent and on reasonable terms, if the trade or industry of South Africa is being prejudiced, or the establishment of a new trade or industry is being prejudiced by reason of the refusal of the proprietor to grant a license or licenses, and if the demand for the protected article in South Africa is being met by importation and the price charged by the proprietor or the importer is excessive in relation to the price charged for the same articles in countries where the protected articles are manufactured under license from the proprietor. So that would be if it's too expensive. So if demand is not being met, if the needs of the Republic are not being, if you can't get it on an adequate scale, if you're holding it back to the prejudice of South African trade, industry, or agriculture, or if you're importing it at a much higher price, these are all instances that you can approach the court for a compulsory license. So an application for a compulsory license must show that the proprietor's conduct falls within any one or more of the categories that are listed above in section 56. And what this means is that the list of these circumstances is exhaustive. So it's one of these 5 and only them, okay, nothing else. In addition, the applicant must have attempted to obtain a voluntary license from the proprietor on reasonable terms prior to applying to the court for relief. There is no statutory guidance on what reasonable terms would be, but it would be something along a reasonable royalty kind of thing. So in other words, an applicant for a compulsory license must show that the rights are being abused in terms of Section 56, and he approached the proprietor, and the proprietor said futsack. And only then can you approach the courts for relief. So it's interesting to note that despite the HIV issues we've had, despite COVID issues we've had, and the vaccines, etc., no compulsory license application has ever been successful in South Africa. And that's an important point. And I think it's because, for a number of reasons, the courts are loath to sort of grant compulsory licenses. They see it as a sort of undermining of monopoly rights, and in so doing, assaulting the notion of the incentivization, encouraging further innovation if they just start giving away rights of proprietors. So the courts are reluctant to sort of get stuck in. Also, and this was the case certainly with the HIV matters and the treatment action campaign round about the turn of the century 2000. I don't think any of you guys, it was 22 years ago. I don't think you were even born then. Well, if you were just little guys. But, so from 1997 onwards, South Africa was being absolutely ravaged by HIV. And there were a lot of these ARVs which were available, but you weren't getting in South Africa. And so the treatment action campaign really went to town to try and force the manufacturers of these ARVs, these life-saving ARVs, to come to the party to say, listen, man, you're not meeting the need in South Africa. South Africa trade, industry, agriculture is being prejudiced because so many people are dying because you're not making these drugs available. There's not an adequate supply. There's a huge demand. It's not being met. And as a result, South Africa is totally, suffering, being prejudiced. So they never actually launched an application for a compulsory license, but the drug companies did eventually come to the party by allowing preferential pricing for South Africa, because they knew that if they went to court, it would be very likely that an application for compulsory license would in fact be granted for these HIV drugs, which weren't being manufactured and imported into South Africa to meet demand. So they had to do something. So what they did was they ramped up production, and they had a special pricing in place for the South African government. And that resulted in one of the world's largest HIV programs being rolled out in South Africa in the early 2000s. And it was all because the manufacturers' backs were against the wall. They were up against the Section 56 compulsory licenses. And they knew that if they weren't reasonable in their negotiations, and if they continued to hold out and conduct themselves as they had been conducting themselves to that point, they would ultimately lose control of their patents by a compulsory license being granted in terms of 56. So to come to the party and to reach a compromise was a lesser evil than having the compulsory licenses granted, because nobody wants a compulsory license granted, because then overnight you have a competitor that you have to deal with. So it's much easier just to reach a compromise. And so it's against the backdrop of these compulsory licenses that these deals have been reached. And it was the same with COVID. So, the guys never really they licensed their patents to Aspen so that in Kubega they could start pumping these things out, yeah. But it was mainly because they knew and they learned from the treatment action campaign that if they weren't reasonable, if they didn't grant some licenses, and most importantly, if they didn't meet demand in South Africa, then there would be a problem and they would be facing an application for compulsory license. So while it's never actually been effectively used, there's never been an application granted, it has been very effective in forcing patent proprietors to be reasonable in how they use their patents. And I think that's really important. Interestingly, on the COVID vaccine thing, it's really interesting for me as to how it sort of worked in South Africa. And, wow, we took our sweet time in getting, these vaccines to come. And there was a lot of discussion about how Africa is at the back of the queue for these things, etc., etc. But eventually, we got our vaccination program up and running, and a lot of people are vaccinated now, and there's a lot of herd immunity out there as well. But what I find interesting is that, they did license Aspen to make this production facility down in Quebec, and there are no orders. That South African manufacturing facility was to supply the African continent. So to say, we will pump it out here in South Africa, and any country in Africa, you just have to buy them from us at a super low price, and we'll make them and we'll send them to Rwanda, Cote d'Ivoire, Sudan, Khartoum, wherever. We're good to go. We can pump them out. We've got the license, we've got the know-how, we've got the hardware. Deafening silence. No orders from Africa. And I just think, wow, man, it's just crazy. But anyway, I don't want to go there. But the fact of the matter is that there were sufficient licensing provisions in place. There was sufficient skills transfer. There was sufficient transfer of the regulation documents and dossiers. We were completely footed to manufacture. I'll be, a little bit, a year or two down the line, but there was the transfer of intellectual property, and it's always against the backdrop that nobody wants to be accused of abusing their patent rights, and in so doing, expose themselves to an application for a compulsory license. So if you look in Dean and Dyer, there's a little grey box there about, despite the HIV/AIDS-related public health crisis and argument that medicines are unaffordable due to the prevailing anti-competitive patent regime, no compulsory license has ever been granted under a South African patent. This may be as a result of the narrow definition of abuse, and this goes to what I was saying earlier about how courts are super loath to interfere, so they tend to take a very narrow interpretation of what the word abuse means in Section 56, and so accordingly it becomes increasingly difficult to prove abuse, and yeah, so it's quite an interesting sort of concept. So yeah. Okay, what we're talking about now is the doctrine of exhaustion of rights as applied to patents and designs. So we have discussed this earlier under infringement, but on page 381 of Dean and Dyer, there is a much more sort of comprehensive discussion on just exactly what exhaustion of rights is and how it works. And basically what it is that, Section 45(2), let me just go back there. The disposal of a patented article by on behalf of a patentee or his licensee shall, subject to other patent rights, give the purchaser the right to use, offer, to dispose, and dispose of that article. So, in other words, the rights in the patentee, once he's sold it, are exhausted, right? So, it's not like he can have a second bite at the cherry. Once he's sold it, once he's got his money, that's it. It's passed from his sphere of influence, and he really can't do anything. And if you've bought and paid for it, then you can on-sell it, you can use it, you can throw it away, you can give it away as a prize. If somebody wants to buy it off you, you can do it. So, that's the concept of exhaustion of right. It gets complicated. And there's only been one decision in South Africa relating to the exhaustion of patentees' rights, and that's Stauffer Chemical versus Agricura, which what happened there was this pesticide, and it was being sold by the licensee in South Africa at 100 rand a bottle. And these guys went and they bought exactly the same pesticide in America and imported it into South Africa, and it only cost them $75 a bottle, and it's exactly the same stuff, And they were like saying, well, we bought it from the manufacturer in the US and we are using it here. So, it's bought and paid for. There's the exhaustion of rights. And the South African licensee was like, no, that's an exhaustion of American rights. I've got the rights here in South Africa. And the guy who bought the pesticide was like, no, it's made by the same person. So I bought it from him. His rights are exhausted. And on that basis, there was a big fight about it. And so as a result, the Stauffer case basically said that where the proprietor himself sells or disposes of the invention, that article is freed from all restraints, and there's an exhaustion of rights. Where the article is disposed of by the proprietor's assignee or his agent acting within the scope of his authority, there's similarly freed from all the restraints, and there's full exhaustion of rights. But number 3, the most important one, where the sale of the protected article is purchased from a licensee of the proprietor, the matter must depend on the extent of the authority conferred on the licensee by the licensor under the license. So what happened in Stauffer Chemical was that when they went to America, they were buying from a licensee. And the terms of the license said, you can only sell this product for use in America. You can't sell this product for use in any other country, such as South Africa. When you buy from the licensee, it's only for use in America. So that was a term of the license which flowed down and meant that the rights were not exhausted because they were contractually curtailed. If they had bought directly from the manufacturer, then you'd fall into that first one where the proprietor himself sells or disposes of the protected article. And so it would have been fine. But in this case, they bought from the licensee, and the extent of the authority conferred by the licensee, that is what meant that the licensee in South Africa had rights, and the rights were in fact not exhausted by the US sale. It's a bit of a tricky one, but a good case, and it's important to understand that exhaustion of rights and how it fits in with the philosophy of patents. I mean, the fact that it's section 45.2 goes to show just how important it is. Okay, guys, 10:30, we're halfway through. We actually are more than halfway through, but what I'm going to do is I'm just going to take a quick break and get another cup of coffee, and then we're just going to talk about hypothecation. We're going to talk about attachment. We're going to talk about the Walt Disney case, which is very cool. Exchange control, which is not so cool. And then finally, the IPR Act, which is very not cool. And then we'll finish for today. So it's 10:30 now. I'm going to take like a 5-minute break, and I'll be back online in about 5 minutes' time. So go grab a cup of coffee, and we'll see you in a few minutes' time. Awesome. Yeah, dinner before I go. Dinner? You're on mute.
I'm saying I have to run somewhere at 11 o'clock, so can I please be excused? I'll catch up on the recording, please.
Yeah, sure, that's fine, 100%.
All right, thank you.
Okay, thanks, bye. And we're back. Okay, good stuff. Hope you enjoyed your coffee. Right. Hypothecation and attachment. Sorry, that was a bit longer. So intellectual property is a thing, right? It's property. And so just like a house or a car, you can do things with it you can collateralize it to raise money. Just like you can raise a bond against your house. You can do the same against a patent. So that's what's called hypothecation. And so the fact that a patent and a design can be hypothecated and in favor of a creditor can be recorded on the relevant register. So as with the recordal of a license or an assignment, a deed of record is used to record the hypothec, so you don't have to go into the gory details of how much and when you've got to pay it back, etc., etc. So the details of the pledge document do not need to be filed at the Patent Office. And therefore, a proprietor who has pledged a patent or design as a security for debt is not entitled to alienate or encumber that item. So you can't assign it, you can't grant a license on it. It's de facto the property of the bank. And the effect of recordal of a hypothec against an item of intellectual property is that the registrar will not record an assignment or a license against that item in the register for as long as the record of hypothec remains on the register. So hypothec is an interesting word. The meaning of hypothec, let me just look it up quickly here. But you know, you would have remembered it from your law of property, a landlord's tacit hypothec, and it comes from Roman law, and it is a right established by law over a debtor's property that remains in the debtor's possession. Okay, so a landlord's tacit hypothec exists over that guy's stuff when he hasn't paid his rent, and it's a hypothec over a patent is when you've lent him money and you take the patent as collateral. So, and you register the hypothec there. So, you know, that's pretty cool. Just like a house or a car, you can raise money against it. Taviso, yeah.
Prof, I just had a question. In terms of hypothecation, how do you actually determine the value of a patent then, Prof?
So patent valuation is a bit of a black art, you know, magic, and I don't know how they do it. Normally accountants do it, and I'm sure the banks would take a very dim view of it, but it's based on things like, do you have a royalty stream? Has anybody offered you any money for it? How much money are you earning from royalties? How much money are you earning from being able to make and sell these products exclusively? That kind of thing. So it would have to be an agreement between the person who loaned you the money, the bank, and you as to what it's basically worth. It's just like, what is my house worth? My house is worth what somebody will pay for it. And so it's the same with a patent. There are ways and means, you know, what did similar houses go for? Am I renting it out? How much rent am I getting? All of these things can be factored in to determine the value. But at the end of the day, it's an approximation and an agreement between the parties. Okay. So just like if I don't pay my debts, they can seize my house. You can also do that. You can seize a patent. So you can be attached. A patent can be attached, for example, for a judgment for recovery of a debt, etc., etc. And you record a warrant of execution or attachment order in the register, just like you can do that against a house or whatever. Yeah, so this is not covered by Dean and Dyer, but another way you can actually use intellectual property to secure a loan is you can, if you've got a patent and you've got a licensee signed up and you're getting a certain amount of money every year, then you can, you can securitize that revenue stream for upfront cash. And I think I might have mentioned Bowie Bonds, about how he did that, whereby he sold 10 years worth of royalties to his back catalog for $50 million up front. And then he went away and bought some copyright in his early work. And then after 10 years, he lived off that copyright for 10 years. And then after 10 years, when the security bond expired, he got his original copyright back. and he still had that which he had spent the 50 million on. So then he owned the copyright in all of his work, and that's called securitization of a revenue stream. And that's a good way of sort of using intellectual property commercially to make money as well. But you can only do that if you've got a licensee locked and loaded and signed up. Okay. The other thing which is interesting is attaching intellectual property to secure or found jurisdiction. And the really good case there is the case of Solomon Linda and The Lion Sleeps Tonight. And you can see in Dean and Diet, there's a little grey box which discusses that, which says that basically, you know, Walt Disney had used the song "The Lion Sleeps Tonight" in The Lion King and a whole bunch of movies and stuff like that. And so because the copyright in The Lion King was determined to belong to the estate of Solomon Linda, a South African citizen and resident who wrote The Lion Sleeps Tonight. He actually wrote the song Wimaware, and then Pete Seeger put words to it to make The Lion Sleeps Tonight. So Solomon Linda was considered a co-author of The Lion Sleeps Tonight, which was used in The Lion King to great effect. And, you know, Spoon Fisher was involved in that case, and we worked out that a lot of money was owed to Solomon Linda as a co-author, co-writer of that song. But Disney were like, "Meh, you guys are in South Africa. What are you going to do about it?" Kind of thing. We're not paying royalties in South Africa. And we were like, "Actually, you are." And so what we did was we went to the Trademarks Office and we successfully bought an ex parte application to attach the various Disney trademarks as well as the copyright in cinematographic films owned by Disney Enterprises in order to found the court's jurisdiction against that company. So we said, guess what? We own your copyright in South Africa. We own your trademarks. So we're going to sell them off unless you come back and pay what's owed to the Solomon Linda family. And they were there like overnight to sort this mess out. And as a result, Solomon Linda and he had passed away. I think he passed away in 1982. But because copyright exists for 50 years after the death of the author, no, 62 he died, yeah, because the copyright in the song expired in 2012. But his family got a lot of money from Disney through us securing and attaching the intellectual property of Disney in South Africa to found jurisdiction to cause them to come back and pay. Because if they hadn't done that, we would have just sold the trademarks on to defray what they owed us. So that's quite an interesting story. The Lion Sleeps Tonight. There's a lot of articles on the internet about that, which is really cool. So you can read all about that. Okay. Exchange control. All right. I don't know if you guys have ever come across exchange control, but we're one of the few countries in the world, on the face of the planet, that has exchange control. But basically what it means is you can't take money, capital, out of South Africa without the approval of the Reserve Bank. Okay, in particular the FSD, the Financial Surveillance Department. It sounds really Orwellian, doesn't it? Something out of 1984. But the fact of the matter is you can't do that. Okay, so they give you $1 million a year as a individual to say, you know, you can go to England and you can use your bank card to draw money to go to the theatre and pay for taxis and stuff like that. Up to $1 million a year, no real questions asked. But anything over and above that, you need our approval. So you can't take Krugerrands, you can't take gold, you can't take anything which is considered capital out of the country. And there's been quite a few cases about it, some interpreting intellectual property to be considered capital, some not. So it's swayed a bit, but at the end of the day, in 2012, they came in and they amended the regulations to the Currency and Exchanges Act that specifically said that for the purposes of sub-regulation 10.1c, capital will include any intellectual property right, whether registered or unregistered, and exported from South Africa. So basically 10.1c says of the Currency and Exchanges Act that no person may, without the approval of Treasury, the exchange control of the Reserve Bank, enter into any transaction whereby capital or any right to capital is directly and indirectly exported from South Africa. Any right to capital. So what does that mean? And then, you know, with the 2012 amendment, it's clear that the term capital includes any intellectual property, whether registered or unregistered. So what does this mean? This means that a South African resident cannot sell and cannot license their patents or their trademarks or anything to a foreign entity unless that sale agreement or that license agreement has been approved by Treasury. Okay, so this is, yeah, this is not cool because consider, for example, a big company like Unilever. Okay, so Unilever operate in every country around the world, almost every country, and they have big operations where they make and sell Jik and Dove and all the different shampoos and everything like that. So if they opened a research and development lab in South Africa and they employed South African inventors, and a local guy invented a new kind of shampoo in their R&D thing, he couldn't assign that to Unilever in the UK without exchange control approval in terms of Section 10.1C read with Regulation 10. Okay, so what do Unilever say? They say, well, that's way too much trouble. I'm just not going to open an R&D facility in South Africa. If every time one of my South African employees makes an invention, I've got to apply it to the Reserve Bank just so that me, the owner, his employer, can own that invention, because he's not allowed to assign it to an offshore entity. He's not allowed to export that capital from South Africa. So most companies just say, forget it, we're not opening R&D facilities in South Africa. And those that do or have or used to have R&D facilities in South Africa close them down, because they said, we're not interested. We don't want to get FSD approval for every time one of you guys makes an invention. So it's much easier just not to invent in South Africa. So this legislation is completely counterintuitive. Because, okay, I understand what it's there for. It's to stop capital flight. It's to stop people walking out with pocket loads full of Krugerrands and just taking all their South African money and exporting it to America or the UK or whatever, buying dollars, buying pounds. Yeah, I kind of get that. Capital flight from South Africa. But, you know, it's a real disincentive for patents. I don't believe it should apply to patents. I think it has a worse effect than what it's trying to do. So, you know, the medicine is more damaging than the ailment. Let's put it that way. So that's exchange control, and you know, it's very contentious, but it's really important to understand that you can't conclude a license agreement with a foreign entity between a local entity and a foreign entity, and you certainly can't transfer any intellectual property from a South African to a foreigner without Reserve Bank approval. And Reserve Bank approval, they make sure things like the correct price is paid, that it's an arm's length transaction, the parties are not connected, there's not a common shareholding between the person, the entity that's selling the intellectual property and the entity that's buying the intellectual property. You know, you can't have common shareholding. And they make sure that the right amount is paid and that the money is remitted back to South Africa. So it's not impossible to get permission, but it's a mission. And it costs about 20 or 30 grand in attorney's fees just to put the application together. If the Reserve Bank approval, because it's not forthcoming because of, you know, whatever reason, they don't feel that it's an arm's length pricing or something like that, then, you know, it's another 20 or 30 grand to do a second application. So companies are just not interested in it. And as a result, there's no investment in South Africa to get these R&D things done. So that's exchange control. And it's just important to understand that if you are commercializing intellectual property, as soon as a foreign entity is involved in a license or an acquisition or an assignment, you've got to get it past the Reserve Bank, and that can be tricky. Okay, licenses are slightly easier, but you still have to get permission. There was, I think in the budget a year or two ago, there was a line saying that they're going to change that, they're going to roll that back, but they haven't done it yet. So licenses still have to be, you have to get full approval, and that can be tricky because it can be done a license approval as opposed to an assignment. An assignment has to be approved by FSD. A license can be approved just by your local bank, but they're not going to approve it unless You can prove that the license is arm's length. It's the proper royalty which is being applied. That the parties are not co-joined, and that all royalties received are remitted back to South Africa. They can't be held offshore. So the bank will only allow it on that basis. So yeah. So there's some that argue that the grant of a license under intellectual property is not in fact required under 10.1c. Some people think it is, some people think it isn't. For me, if it's questionable, just get the approval, then you're done. But in any event, any royalties received have to be remitted to South Africa in terms of that Treasury Act. What is it? The Currency and Exchanges Act. So that's important to remember. Okay, the last thing I want to chat about today is the Intellectual Property from Publicly Financed Research and Development Act. So this was an act that was introduced in 2010. And basically what it says is that if any intellectual property is created by an entity which is the recipient of public funds, then the requirements of this act apply, and there are certain obligations placed on the proprietor of the act. So I'll just read from Dean and Dyer, and it's a really good sort of summary of the act, and then I'll go through again what the effect of this is and how it's influenced technology in South Africa. So in 2010, the act came into force, and it aimed to regulate the identification, protection, utilization, and commercialization of intellectual property that results from publicly financed research, okay, to ensure the benefit to the people of South Africa. And so the act only applies to intellectual property, including know-how, but excluding copyright, which is curious, created with public funds. And what it is that this now has huge implications for public research institutions, most notably universities, because universities get huge government funding in everything they do. I know that you guys have all paid, tens of thousands of rand to be part of this program, but believe me, for every student that UJ has, the government gives probably more money than you've paid to pay for the facilities and the lecturing and the consumables and the chemicals used in the lab and the rats and all sorts of things. So universities are the recipient of massive government grants, so they fall squarely within the IPR Act. Okay, and obviously the other one would be research councils like MinTech, the Council for Scientific and Industrial Research, the CSIR. Okay, but what it really has an effect on is private companies that wish to engage with the CSIR or the university to get some research done. Okay, so in other words, private entities contracting with public institutions to conduct research or development previously were free to negotiate and agree on the commercial terms of their engagement. But the IPR Act makes certain consequences of the relationship with a private entity unavoidable. So, for example, public institutions, which, for example, a university, which creates intellectual property with public resources, must own that intellectual property, okay, regardless of what might have been agreed with the private entity. Furthermore, that proprietor, the university, may not assign the intellectual property to a private entity and without the approval of the National Intellectual Property Management Office. And in addition, the private entity cannot own that intellectual property unless it satisfies 4 criteria. 1, that there was a contribution of resources, so that they threw money at the problem, that they at least helped create the intellectual property. There had to be a co-inventor. Appropriate arrangements are in force for benefit sharing for intellectual property creators, and that the institution and the private entity conclude an agreement for commercialization of intellectual property, and in particular benefit sharing for the inventors of the university. So all of a sudden you have an Anglo-American, you have an Implats, they go to a university and they say, we'd like to sponsor a PhD student to solve this problem, how to extract more gold from rock. And the university says, cool, how much do you want to? And they say, we'll give you guys 50 grand. And hopefully that'll sponsor a dissertation. Well, it's not going to be 50 grand, it's going to be 200 grand, right? For a PhD student for 2 years to work on this. That's great. So they give the university 200 grand. This university student solves the problem. He goes away, gets a lab, Anglo pay for everything, comes back, says, here's the solution to your problem. Anglo don't own it. If Anglo didn't have a co-inventor in there as part of that dissertation, if they didn't insert one of their guys into the lab to help the PhD student, they don't get to own it, no matter how much they're paid, okay? The university owns it. And what's more, they can't even license it to Anglo, who paid for it all, unless there's appropriate arrangements for benefit sharing and there's an agreement and NIPMO agree. So like implants are like, no, that's ridiculous, I'm not going to pay you 200 grand and then I don't even own it. And then I'm lucky to get a license of it. And NIPMO might say, well, now you've got to license other mining companies. So all of a sudden my competitors get a license to this, which I've bought and paid for, this technology. So how about no, So then the Act said, okay, well, or you get excited. They built in a limitation and they said, if the research undertaken by the public research institution, for example, the university, is funded by a private entity on a full cost basis, then the intellectual property created will fall outside the ambit of the Act. So what's full cost? Okay, so full cost is calculated in accordance with international financial reporting standards, and it's left to every university to say what's full cost. Okay, so whereas it used to be 250 grand will buy you a PhD student for 2 years, and then you get to own the intellectual property. Now you have to say, well, what's the full cost of that PhD student for 2 years? And that gets quite tricky because it's not 250, it's probably about 750, because you've got to discount all of the government funding and all of the other funding that the university gets in respect of that lab, in respect of that guy. So now all of a sudden, if Implats want to own the intellectual property, they now have to pay 750,000 as opposed to 250,000. And it's really up to the university as to what they set their pricing at. But that's the effect. That's the only way to get out from underneath the IPR Act, is to just throw money at the universities to make sure that the funders, the private entities, actually own the intellectual property created as a result of that. Okay, so there's also, if you don't do the full cost thing, you don't own it, and you're really constricted as to how the university can commercialize it. For example, the university must prefer non-exclusive licensing over exclusive licensing. And where feasible, the manufacturing, processing, commercialization must take place in South Africa. So it's a very honorable act. I can totally see where they're coming from. And to be fair, it's based on international best practice, because there are other countries which have very similar legislation. In the US, for example, it's called the Bayh-Dole Act. You can look it up on Wikipedia. But the fact of the matter is, like exchange control, it's had the opposite effect. People just say, you know what, I'm not gonna pay for all of that. Why? I can just pay an English university that doesn't have this requirement and own the intellectual property. Why should I have to spend twice as much in South Africa? So I had a very interesting conversation about 10 years ago with a major international company that had decided to shut down its South African R&D and manufacturing abilities. And I was like, you guys have been in the country for 50 years, but it's now 2011, 2012, and you're going. What's changed? And they said, the IPR Act. It's the straw that broke the camel's back. And I was like, yeah, but, America's got their equivalent IPR Act. They've got the Bayh-Dole Act. Why is this the same? And this guy looked at me, and this English attorney who was head of department for this R&D unit, and he said, it's true, John. A lot of other countries do have the equivalent of the IPR Act, but those other countries don't have exchange control. They don't have load shedding. They don't have the unionization of labor that South Africa has got. So all of these factors, you know, you lay on the camel, and then the camel just collapses, you know. So yeah, I think, you know, this is an example of Western solutions to African problems, and that doesn't work. You know, South Africa has got unique problems. We need unique solutions. You can't just slavishly apply a European solution to South Africa, because it doesn't work in context. You know, load shedding is a huge problem for manufacturing and R&D in South Africa. If you've got a growing cycle that lasts for 4 or 5 days, you know, you're growing a population of bugs, you're growing a synthetic diamond, you are melting a whole lot of rock, and you've got to have that heat and that pressure going for 4 straight days, and you have load shedding on day 3, you've wasted everything up until then. Your population dies, your diamond stops growing, and you can't restart growing it again. Your population of bugs dies. The metal cools in the refractor, then you have to chip it off. You know, it's massive. The costs are enormous, and R&D is the one that suffers the most from this kind of thing. You know, manufacturing is one thing. Oh, your line grinds to a halt, but no worries, it'll be up and running again in a couple of hours, and we'll take it from there. To throw away 3 or 4 days worth of work, all of the natural ingredients, and to throw it all away and start again when load shedding could happen again in 3 or 4 days, it's devastating. Okay, so that in itself is a huge strain on R&D in South Africa. Then you say, well, if you manage to solve any of those problems, you can't transfer those rights offshore to the mother company, who's in fact paying for all of this. They're like thinking, oh, this is not cool. And then you say, oh, and if you used a university and you didn't pay 3 times the cost of what it's supposed to be, then guess what? You don't own that intellectual property anyway. It's owned by the university. So, you know, the culmination of all of that legislation is just like, they're like, okay, you know what? We're done. Thanks for playing. We're going to do our research in the UK. And then we're going to license the technology into South Africa. So you guys have to pay to use it. So all of this legislation is counterintuitive, okay? R&D has suffered terribly in South Africa, and you can see that from the local patent filing numbers. The numbers are about the same. It's always about 10,000 applications a year, but the local numbers are dropping and overseas numbers are increasing because the R&D is being conducted overseas, but it's been licensed in South Africa. So you have to file your patent application in South Africa to license it. But South Africans are paying to use that technology instead of being paid for other people to use our technology, which we are well capable of inventing. So all in all, it's a bit of a sad story, and this kind of legislation doesn't help. But it is what it is. We as South Africans are extremely resilient. We're very good at inventing. We're very good at problem solving. But unfortunately, we're being let down by a legislative framework which doesn't facilitate using our potential. And for me, as a patent attorney, seeing the tide turn like that over the last decade, it's quite sad. But anyway, it is what it is. We have this legislation. You guys are the next generation. Maybe you guys can change it. I hope so. But that's what we have. Okay, guys, that's everything for today. It's 11:10. I think we can be released. The next one is next week. We've got 2 on the trot, I believe. 7th of May, and the next one is the 14th of May. And that one's going to be a pretty light one: international arrangements, USPTO, EPC, biodiversity, South African IP policy. The South African IP policy is a good one. I'll send you a copy of that in the meantime, and you should have a look at that, because that is a document which is looking to address the perceived shortfall in the South African patent legislative framework and how they're going to try to fix the problems. So it's talking about substantive examinations, talking about opposition, etc., etc. So the South African IP policy is very interesting. And then after that, we'll just have one final lecture on the 28th of May, and then your exam is on the 15th. So yeah, I think the end is in sight. You guys are doing good. And that's everything for today. And I'll see you 9 o'clock next week. unless there are any questions. I see no hands up, so I think we're good. I will post this recording onto Blackboard. I'll post a few other things, the list of 27 questions, etc., etc. I'll send you guys the IP policy so that you have read it for next week's lecture, and I'll send each of you individually your assignments, and I'll post the memo on Blackboard as well. And otherwise, that's it. Everything from my side. I'm good. I'm going to go. No questions. It's been good. Thanks, guys. We'll see you next week.
Thanks, Prof.
Okay. Thanks, Tabiso. Thanks, Sally.
Thank you.
Okay. Bye now.